SJC-13127 in the matter of an impounded case.
Attorney Self.
Yes, good morning. May it please the court. My name is Rachel Self, and it is my privilege to be here today representing Mr. Noah Campbell-Halley. Your Honors, this matter presents a straightforward question where a defendant has firmly demonstrated that he is entitled to social worker treatment records, and those records were erroneously destroyed. Did the motion judge abuse his broad discretion permitted to him to remedy extraordinary circumstance issues in allowing a limited deposition of the social worker to replicate the information in those records? As an initial matter, Your Honors, it is our position that BR does not have standing to bring this case before the court. The Rule 17 protocol allows the Rule 17 hearing to be the only opportunity for the party or non-party to voice their objection. We had that hearing more than a couple of years ago, and ultimately the Superior Court Judge Rufo determined that we were entitled to the records and we had satisfied the Lampron-Dwyer protocol. At that point, no appeal was taken. There is no standing for a non-party to file a 211-3. So at this point, we don't believe that we should be before this court on a 211-3 in a pretrial matter to address this when we have already had the full Lampron-Dwyer protocol hearing determining that these records were necessary for the defendant to provide a defense on the case.
The situation's changed, hasn't it, counsel?
It actually,
the records are not available.
well, yes, so that's the issue, but the information in the records and the fact that the information in those records were necessary to present the defense in this case, that hasn't changed. And so what we've been trying to do in light of the extraordinary circumstances in this case is appreciating the fact that Lampron-Dwyer did not ever mention deposition as an option in curing, in obtaining information. Lampron-Dwyer also did not anticipate records being erroneously destroyed and not being.
Lampron-Dwyer is a protocol, as is Rule 17, to gather existing information. There's nothing,
Exactly.
and you've probably been involved in Lampron-Dwyer situations where you say, are there any records? And the response to your chagrin is no. And then the next response is, well, go get some, go make some.
Well, and Justice Gaziano, that's not what we're asking to have happen here. And as you very aptly pointed out, what we're seeking is information. And typically the way that information is maintained is within records, or at least that's how that's normally done. However, as the case law has made very clear, sometimes the information is not necessarily in records. Sometimes it's in data, sometimes it's not maintained in paper, that kind of thing. But in this particular instance, the records were supposed to be maintained and simply were, it's our position they were destroyed in violation of the social workers' ethical obligations.
I think I agree with you that the judge, under just general Rule 14 authority, had the ability to fashion a remedy for the inadvertent destruction of the evidence, that being the summary, right? Why isn't that enough?
So the summary, Your Honor, isn't enough because unfortunately the summary doesn't provide any information. First of all, it's our understanding that there were a minimum of 6 sessions between the initial SANE and the second SANE. And what was provided was a 1.5-page summary that did not go into any of the it didn't go into any of the protocols, the practices, the way questions were asked, and so the position that we're in here is a very difficult one in that we already know we have.
But how is that different if you got Lampron-Dwyer records and they just were summary in nature, and then you said, geez, this isn't real useful. I'd like to see how the question was done. All those questions you have during cross-examination that naturally come out that you were fighting for your client for. I understand it, but
No, you're directly,
oftentimes records are incomplete.
And you're directly on point, Your Honor, but at least we would know and have the ability to effectively cross-examine. For the opportunity for the defense, and P.S., it's also presuming that the Commonwealth is going to call Ms. Sayward and we're going to have the opportunity to cross-examine her. At this point, we would then have the records, or how the records weren't maintained, or what wasn't done and how it wasn't properly done, or the opportunity to discuss it with our expert and say, listen, this wasn't done, that wasn't done. Oh, they don't have this, they don't have that. At this point now, what we do know for sure is that we have a social worker who failed to maintain the records, who absolutely did not follow protocols, who also failed to follow orders of the court. So we have a situation where there's somebody who clearly doesn't necessarily understand how things might properly need to be done. And the first time that we're supposed to explore that is at trial. I mean, even as common as we know, dependence on improvised cross-examination, no matter how virtuistic, is not going to necessarily be the best way to go about this. And we have the opportunity right now.
Can you help me? Let me just say a clarifying question for me, please. Is whether or not she's going to testify, the social worker, dependent upon whether or not she's called as a first complaint witness?
No.
Okay.
No, she is not the first complaint witness. Ms. Sayward became involved because
the child mentioned to the parent or somebody, right? That's the first complaint.
There was, so the disclosure, this is another issue that we're dealing with in this case, Your Honor, and there's quite a few of them, but one of them is that the disclosures have never been, there's never been some clean disclosure here. This is a very, for lack of a better term, it's not a clear-cut case. This is not a situation where the child went to a doctor and had observed some sort of physical injury, or the child very clearly said to his parents, "Mommy, Daddy, this person is touching me." There is never
you know very well how rare that typical case you're talking about is actually the typical case. That's the antithesis of the typical case. But while I have you, why isn't everything that you're raising issues of discovery, which is really inconsistent with Lampron-Dwyer?
Absolutely, Your Honor, because we already know that these meetings, we already know that these sessions happen. And at no point are we seeking to obtain new information or newly discovered information or go on any sort of fishing expedition. And 3 Superior Court justices at extensive litigation at the lower level determined that we were entitled to the information in these records. So it's not a discovery tool that we're using here. We know that these meetings took place. We know that the child went from basically saying, we didn't have chicken last night, to saying, no, we had chicken, mashed potatoes, stuffing, gravy, and P.S., let me ask my mom to be sure that we didn't also have dessert. This is a situation.
Can I get a clarification again? And maybe I'll ask the Commonwealth, but whether or not she testifies depends upon what, in your view? If it's not first complaint, why is she going to testify?
Your Honor, at this point, what the reason that she would testify would be to, well, and whether or not the Commonwealth calls her, as I said, I don't necessarily know that the Commonwealth would, but we would then potentially call her, or, and at this point, also, unfortunately, this is one of the limitations that we're dealing with, is whether or not we would, because we haven't had an opportunity yet to see how she examined this child, and whether or not the examination was suggestive, and whether or not how the questions were asked, what theory was used, what practices were put in place.
Have you ever seen social worker records that have that in them?
Well, Your Honor,
all those niceties about what theory was used and how they question.
No, and it's a very good point in that no case is ever a perfect case. Nobody ever gets a slam dunk case, but typically a case is not this
what my understanding is, they're going to put their case on, and there's going to be evidence that there was a non-disclosure in the first SANE interview, right? And then you're going to cross-examine everybody and say, you had a chance, you were comfortable, you spoke to these people, and you didn't say anything. That's how these things play out. And then it could come out that she disclosed, the victim disclosed to the second, to the therapist, and then there was disclosure. But I'm still not getting what your deposition is going to do other than give you information you wouldn't otherwise be privy to, were those
we don't know
records
that.
in existence?
So the unfortunate reality, Justice Gaziano, is we don't know that because we've never had anything to look at or see because they were unethically destroyed. A social worker is required to keep the records 7 years past the age of majority for any minor that it interviews. She is the highest level of social worker with recent renewed licensure, knowing that she needed to do this. And unfortunately, to your point, we simply don't know whether the records, we don't know what they contain because we simply have been provided with pretty much nothing at this point. So what we are attempting to do is ensure that we are effectively representing Mr. Campbell-Halley, that we are preparing our defense, that we are calling the experts that we feel are necessary to have that ability to make that defense. And you're absolutely right. If the records had been maintained and complied, that's what we absolutely would have preferred, because then I would have known that I had done my work. I would be able to then effectuate my strategy on what the appropriate defense is here. And obviously we have now, it's basically it's a mystery now, and it's a mystery.
Can I ask one question?
because-
Can I ask one question? Has there
Yeah.
ever been a Lampron Dwyer deposition ever?
So at this point, Your Honor, what we have seen is we have seen depositions, and I'd call the court's attention to something that was, it was a very similar case, but in the record appendix at, I believe it's either 609 or 610, we have an affidavit, and unfortunately her case was sealed, but we have an affidavit from attorney Janice Basil, who in a situation similar to that, where the records were ordered to be provided and they were destroyed, Judge Botsford, who was the judge in that case, ordered a deposition of the psychologist in that case. And Miss Basil, and I believe it was Mr. D'Angelo, went to Nevada and took this deposition to obtain the information that was
That's
out
a
of
trial level. So there's no appellate case ever saying you can have, because I assume we have, unlike you and Justice Gaziano, I haven't seen thousands of these, but I assume we have bad note-taking sometimes by social workers or psychologists. So, but we have no appellate case ever ordering a deposition.
Well, what we do, because there have been cases where motions for new trials were ordered, and then ultimately the records were destroyed. And so then the judge said, okay, well, we need to try to recreate this record. And so you can.
But Justice Cipher did do that. I mean, she did approve the summary. So we have the summary.
But Your Honor, the summary does. It's our position that when you have a social worker who at our July 14th hearing that we had with Judge Fishman, the social worker admitted she didn't even know the difference between a record and a summary. So while we have this summary that was provided by her, that is basically a 1 1/4 page summary to what would have been 6 treatment sessions, when she admits that she doesn't even necessarily know what a summary is, it's absolutely it's very concerning to then say, at a pretrial stage. And again, I keep thinking that this is where this case has the opportunity to really prevent an injustice, is that we are still at the pretrial stage. So to be complaining that we don't like the dessert menu when we haven't even chosen the restaurant yet, we still have a lot of protections in place for BR in this case after a determination.
Aren't you changing the Rule 35 standard?
No, because depositions, because we've already addressed. So Rule 35, we're not trying to use Rule 35 to get around Rule 17, because we've already established that the privilege is pierced in this case. So Rule 35, and we've extensively briefed it in our briefs, allows for depositions in extraordinary circumstances. What we really think is the most appropriate remedy here, Your Honors, and as we proposed to Judge Gilday in our motion for appropriate relief, is that this testimony should be excluded. But what he did was he utilized his broad discretion to craft a remedy to make sure that the interests of justice were protected, but also the Commonwealth's interests were protected. And as we very well know, no matter how
Counsel,
compelling-
can I ask you a question, Counsel? Is the point of the deposition that was ordered was to recreate the destroyed documents, right?
The point of the deposition was to obtain the information that would have been in the destroyed documents.
And what is the difference between your answer and my question?
Well, I think the difference is we're not looking to obtain any information we weren't already entitled to. We're not looking to dive down and get completely superfluous.
And you think the records would have shown that this social worker improperly asked questions, suggestive questions? That's your position.
My position is, unfortunately, we simply don't know. And so what
But if the point of the deposition is to recreate these documents that have been inadvertently destroyed, as the judge found, it seems to me that your deposition, if the point of it is to recreate it, would be limited to what was in the documents.
absolutely.
That's no longer available.
Exactly.
And so in order for you to say that, the chicken dinner versus the dessert menu analogy that you're making is, it would seem to require us to believe that these destroyed documents somehow reflected the social worker's improper questioning of the victim.
So I don't necessarily agree with Your Honor, because at this point, what seems to be missing in the analysis is the fact that we have not been provided with anything.
Well, you
And
have
so-
the summary.
But this, again, Your Honor, it's our position that the summary is not sufficient because we don't even know how many times she met with this child. We don't even have.
I thought you
her
said it was
records-
6.
No, what we have is a presumption based on DCF records that she had met with him approximately 6 times. But what Judge Fishman was trying to do in the July 14th hearing was determine by ordering the mass health records, at least even how many times this child definitely met with this person in that period. We are so limited in the information that we have that and the idea that we would be flying blind when we have the ability to remedy this injustice pre-trial. That's the thing. It's not, he hasn't been convicted yet. We have the ability to craft a remedy pre-trial here. And as Your Honors very well know, this is the time where no matter how compelling the justification for privilege, if honoring that privilege has the effect of depriving the defendant of his constitutional right to a fair trial, we have to give higher priority to the constitutional right and not the legislatively created privilege. So in this situation, unfortunately, Your Honors, we know that there were these meetings. We know that there was this treatment. And unfortunately, at that point, we are blind. And even if the records were limited, as Justice Gaziano suggested, and even if they weren't ideal, and they never are, we'd at least have something to work with. And it's so significant in such a tenuous case for the Commonwealth, where we have uncorroborated, unsubstantiated, conflicting stories, where the child says, it happened on Mondays, and we have teachers saying it didn't happen on Mondays. How did these answers, how did this saying go from A to B? And that's what we're trying to figure out. And it's not, and it really does hinge on, particularly because of children's susceptibility to questioning, it hinges on how, on even what technique was used, we don't know, right? So this is and with no ability or records or anything, and presuming even if the Commonwealth does not call her and say, I called her, and then I'm trying to question her, and we're presuming she would show up, because she certainly doesn't necessarily respect court orders where a capias had to issue for her to come to court. And so then she says, I don't remember, and I have nothing to work with, impeach a trial, to do anything to defend the case. So it is a significant issue, and appreciating the fact that, and understanding why in BR's brief and in the Commonwealth's brief, of course, we're not seeking to turn Lampron Dwyer into deposition dance days, right? That's not it. What we're simply trying to do is utilize the Superior Court Judge Gilday's broad discretion remedy that he crafted, which Rule 35 absolutely permits, and we cited to several cases in our brief, in certain limited circumstances where depositions have been appropriate. And it's our position that in this case, it is appropriate, appreciating the extraordinary circumstances.
Okay,
Thank you very much. If there are no further questions, I know I'm out of time and I'd rest on my briefs. Thank you, Your Honors.
Attorney Foote.
Good morning, Your Honors, and may it please the court. Catherine Foote on behalf of the appellee, the victim witness. The single justice's decision should be upheld for 3 reasons, but before I address those reasons, I'd like to start by addressing a few points raised by the defendant. First, as to the Superior Court order, the treating social worker in that case was out of state and located in Nevada, which is often which often is provided for under Rule 35 for depositions because the witness is outside of the subpoena power of the court. In addition, for recreating the records in a motion for a new trial, in those instances, often Lampron-Dwyer wasn't an issue there. So the situation is entirely different than this situation here. In addition, if you look to pages 579 and 580 of the record appendix, which is where the defendant's proposed protocol for the deposition is located, the subject of the deposition is incredibly broad. It's all treatment of BR between April 2nd and May 7th. And Ms. Sayward has no ability to refuse to answer questions regarding BR's treatment during that time period on the grounds of privilege. It's not a limited deposition that would be just what was included necessarily in the treatment records.
If it were more limited, would that have been okay?
No, and it wouldn't have been okay because the situation here does not fall within the Rule 35 requirements for a deposition.
I am curious though. So if the notes are, if the summary is shoddy, say she just prepared a 2-sentence summary. I took notes. So you wouldn't be able to then flesh it out because she's trying to use I understand she's trying to use the deposition more broadly than that. But if she were using it just to recreate the notes, would that still be a problem?
I think there's a few issues there. First, the summary isn't the only piece of information from Ms. Sayward. There were 2 emails provided that were contemporaneously created during the treatment. So she has both 2 emails, which include information about the treatment and the summary. And as you all have discussed, she has the ability to call her on the stand and ask these questions. It doesn't have, asking these questions prior to trial is in fact a deposition as a discovery tool, which is not.
But counsel, I guess in both your brief and the Commonwealth's brief, I don't know that I fully appreciate or that I get a sense that you appreciate the optics here. You have someone who, after an initial interview, makes no allegation against the defendant, has these treatment sessions, and then there's an allegation. And what I find troubling is we know that the complainant met with the clinician. They asked Mass Health for the records. Mass Health doesn't give any records. So we don't know how many treatment sessions they had. And let's just presume for the sake of argument that it's 50 minutes. So if there is some indication that was at least 6, so there's about 6 hours worth of session time, and they've a page and a half summary and 2 emails somehow balance that scale.
While I understand the concern for the missing records, as the court has found, the lower court has found, the records were inadvertently destroyed. There was no malice here.
I'm not saying that there was, but the court has said, because irrespective of how, and Judge Fishman credited that it was inadvertent, but irrespective of all of that, there's missing information that arguably the defendant's entitled to and now doesn't have to what would be really important to be able to figure out what to do in terms of how they address this particular issue with the subsequent allegation, right?
Yes, and in this instance, what the court determined was an appropriate remedy was the summary. And providing the emails that were outside of the range of the original Lampron-Dwyer allowed summons. Whether the summary was exactly what the defendant was looking for, I mean, often the records aren't exactly what the defendant is
Well,
looking
if you're
for
focusing
either.
on Judge Fishman, I'm focusing on Judge Gilday. And Judge Gilday said deposition.
Yes, but in doing that, Judge Gilday failed to adequately review the Rule 35 requirements for ordering a deposition. And in ordering a deposition in this case would be going entirely outside the bounds of Lampron-Dwyer. And now Lampron-Dwyer is solely for the purpose of producing documents. And to take a Rule 17 request for documents and turn it into a Rule 35 deposition is meshing together two different rules that have entirely different requirements and purposes from one
Didn't the
another.
judge have the authority under the judge's general authority to remedy discovery violations? I understand that Rule 35 is to perpetuate testimony. If the witness is available, you don't get the depositions. That's clear. But to Justice George's point, doesn't the trial judge's general authority to remedy violations give the right to kind of craft this to allow for this?
While the judge does have general authority to craft discovery remedies, Rule 35 actually doesn't provide the judge with the same level of discretion as other discovery rules do. Rule 35 is a more limited requirement, and it requires the judge to make certain considerations for exceptional circumstances. It's not a broad discovery rule in a similar way that Rule 17 would be, and allows for crafting a remedy.
Why isn't it an exceptional circumstance that these documents existed at some point and while inadvertent were destroyed to the detriment of the defendant? And so the best way, having seen the summary, and the two emails, the best way to solve this unfortunate destruction is a deposition of the clinician.
And could I
Why
add
is that not an
something?
abuse of discretion? Why is that an abuse of discretion? I mean, it seems to me that whether or not we would think it was appropriate, if we were the trial judge, why does it make it an abuse of discretion for this judge to order this remedy in this particular extraordinary circumstance?
And may I add to Justice Wendland's question that you also have to overlay here that this record holder was required to keep it. This isn't just something that just kind of disappeared. She had an affirmative duty to keep these records and did not. So why isn't it, going back to Justice Wendland's question, why aren't these exceptional circumstances?
Under Rule 35, exceptional circumstances is for not for creating evidence or creating testimony.
But this
prior to
evidence
trial.
existed. It's not a new creation. It's a recreation of something that was inadvertently, but unfortunately destroyed, that the defendant says is necessary for his defense.
But ultimately, a deposition wouldn't make the defendant whole. It wouldn't create these records. The records are gone.
Is that
They-
the standard for
he
abuse of
can't get
discretion,
them.
whether or not the defendant is made whole?
No, it is not the standard for abuse of discretion, but here it is an abuse of discretion to apply Rule 35, which is not a discovery tool, which is not for the purposes of obtaining evidence prior to trial. Rule 35 is for the purpose of getting testimony that is material to the case that otherwise you can't get at trial. And here, there is nothing to say that the witness, that Ms. Sayward, would not be able to go to trial and provide that testimony there.
Well, there's a suggestion, if you take Lampron-Dwyer and the records need to be produced because they were destroyed, and you take Rule 35, which is an extraordinary circumstances to preserve some testimony that you might need for trial, and the trial is going to be, I don't know, a year from now, 18 months from now. We've already got issues with the social worker. Can't the judge take into account that memories fade and it's better to get what those records were now as opposed to a year and a half from now?
Well, first, every other witness at the trial is going to be waiting and having their memory fade in the same way as in theory, Miss Sayward, the social worker, will. I mean, there aren't depositions of every other witness in this case to preserve their memory. But additionally,
It's not the memory of what they observed, it's the memory of what was in a document.
and we've done that already with the summary. That was the preservation of her memory by crafting that solution, by providing the summary to the defendant.
Okay, if there are no further questions, we'll move
you.
on to Attorney Campbell.
Good morning, Your Honors. Karen Palumbo for the Commonwealth. First, I'd like to touch upon Attorney Self's statement regarding the SANE interview, which I'm sure you're all familiar with. First, this is a 6-year-old sexual assault victim. In the first SANE interview, I would suggest does not have no disclosures whatsoever. He's speaking to his parents initially, and then in his first interview with a person he doesn't know, he says he doesn't like technology. I don't like that. You want to know why? And he says, everybody goes on computers, but there's not enough computers for me. And I have to go in another room and the defendant makes me play games. And they're really hard and it's not making like technology. The victim, he said he always went into another room because there were no computers for him. Usually the door could be open or shut, and sometimes the lights were on and off. He also said one time when the lights were off, someone walking over, another student accidentally touched this. It was his private parts, and he said it's what you go to the bathroom with. So he continued to say kind of general statements, and when the interviewer pushed him a little bit, regarding what he discussed with his parents, he said, this is the 6-year-old victim.
Counsel, can I ask you a question?
Yes.
Is the summary of an abuse of discretion, the creation of the summary?
I believe it is, but the summary's already been created. Defense counsel has already had access to that summary. So, and Justice Cipher found that it was not an abuse of discretion.
And
although
you're
she
not
herself,
appealing that?
we're not appealing that part.
Okay, so
We're
so
just
the
appealing-
summary is appropriate, even though you disagree.
Yes, we disagree.
So
It's
given that
appropriate.
the summary is in, why is it, what's the difference between the summary and the deposition that makes it such an abuse of discretion?
Well, first and foremost, the purpose of the deposition for the defendant is not to preserve testimony. It's not even to recreate testimony. Attorney Self says the purpose is to investigate the credibility of the victim's allegations and the propriety of the therapist's treatments.
So I go back to Justice Kafker's question, is a different scope of deposition
Permissible?
appropriate?
No, I don't believe so. For depositions, it is a narrowly construed rule. And it does, this court's aware, it applies only in exceptional circumstances. Usually the witness is not going to be available to testify at trial. The testimony that the defendant may not be able to get would be an injustice. And the other factor is whether it's unjust to the non-moving party. And I would suggest that here, where the defendant would have unfettered access to the victim's privileged information, that is definitely unjust to the victim in this case. Also, as Justice Cipher
But I'm
pointed out,
confused. If Lampron Dwyer is satisfied so that he does get access to the notes, all we're doing is putting him back to where he would be before, which is having access to the notes.
during this deposition, the notes,
I understand the deposition may be hard to rein in and may be impossible to rein in. And that may be why no one's ever done one. But
I would also suggest, as Justice Cipher said, it eviscerates the Dwyer-Lampron protocol. Under Dwyer, if records are disclosed to the defendant, they're held in camera in court, and the defendant is the only one who's allowed to see them. There are special protections in place to protect victims in cases like this. And eliminating those protections would risk victims being able to speak honestly during treatment, because all of their information would be unfettered depositions in every case. I think this is important in this case.
That's overstating it, isn't it? Because again, it's going back down to the trial judges that had an opportunity to look at this. This isn't unfettered. There is a specific instance where these records inadvertently were destroyed. They were discoverable. The judge ordered the records produced under Rule 17. So this isn't a situation where folks can just walk in and ask for depositions in every case. There's specifics to this case as to why the judge has said not only is he entitled to it, but now because they don't exist, we're going to order as a remedy that this deposition happen.
Well, I would suggest in this case, this was, and contrary to what counsel said, it's not unethical or illegal. She did have an obligation to retain these files, but there was a show cause hearing in the trial court, and they found that the records were inadvertently destroyed. There was no culpability on anyone's part in this instance. And
Well,
I
that's
agree-
not true because the Commonwealth also said that she potentially has criminal exposure, right? Didn't you say that in your brief?
That is in the Commonwealth's brief.
Right, it's in
yes.
here. So that's an overstatement. Okay, all
Okay.
right. So let's start there. So we have something where we have a clinician who's got a statutory responsibility or regulatory responsibility to keep these records. They're not there. And I guess I'm just still struggling to find where it is that we should just say to the defendant, you were owed these records. The judge looked at these things and said that under these circumstances, the extraordinary relief of a deposition is warranted, that somehow there's an abuse there. If you could focus on that for me, because again, it's not substituted judgment. It isn't what you or I would do. But in this case, what the judge ordered, tell me why that is an abuse of discretion.
It's an abuse of discretion because the defendant has material. She has the letter and the email. She also has the summary. And most importantly, she has the 2 SANE interviews. And I wanted to point out to the court that there's clearly some disclosure in the first SANE interview. As I said, when the victim was being pushed as to what he said to his parents, well, okay, fine, I'll tell you this. It's what when I hurt my leg, he knew I did. And he said, take your pants off. And that's why I didn't want to go to school. So in this first SANE interview, he's saying there are not enough computers for us. So we go into a separate room with the defendant and he tells me to take my pants off. I disagree with counsel's representation that that is not a disclosure. I do agree that the second SANE interview is much more detailed and specific, and defense counsel is free to investigate that or cross-examine the victim and the therapist at trial. And as Justice Cipher found, that is his remedy, is a thorough cross-examination.
Well, can he, the issue is preparing adequately for trial, because it's difficult to ask these type of questions blind in front of the jury. But if we just take a step back for a moment, what happened was under Lampron-Dwyer, there's a presumptive privilege, right?
Yes,
So the records are called in, but they don't come in.
right.
So what you're saying is this is not the functional equivalent of having a ruling about what would have happened at trial, but that the defense attorney, subject to a protective order, could have viewed the records.
Correct.
Okay. So why isn't a reasonable answer to this, rather than have the defendant have to blindly cross-examine, to have some sort of voir dire at trial with the judge on the bench, as opposed to a deposition, to get right at the issues addressing the presumptively privileged records?
At this point, and even when the records have been turned over to the court and defendant can view them, the privilege has not been waived. The therapist in this case will be subject to a deposition, which is only to preserve evidence, at which she cannot invoke the patient therapist
Oh, I
privilege.
understand that. I appreciate that point. I'm saying if there's a concern, a legitimate concern, and I think there is, that the defendant not have to cross-examine blind here, why couldn't, subject to the availability of those objections, be a voir dire, so that there can be adequate preparation for cross-examination?
The defendant isn't requesting a voir dire.
What do you think of that as a remedy?
It may be an option. It certainly may be better than this option, which I believe is not permitted by the rules. And it is an abuse of the judge's discretion.
You're not calling this social worker as a witness, right?
The Commonwealth will be calling her, yes.
Will,
I believe so. I'm not the trial attorney, but
for what purpose?
to testify as to her treatment of the victim.
As to statements or just general treatment?
Probably just general information. We aren't privy to the statements or what went on during the therapy sessions. We're not privy to that.
Did you get the
information.
summary?
No, we have not viewed the summary. We're not entitled to view the summary. It's
This is-
sealed. It's for the court and defense counsel only.
Okay.
Okay.
If there are no further questions, I'd ask that the court affirm the single justice's order vacating the deposition.
Thank you.
Thank you.